to get started, guys, because I have to leave my house here. I'm working from home today, but I have to leave at 12:45 for a doctor's appointment. So we're going to get started. For those of you who do not know me, I'm Tom Fulkerson. I'm your qualifying broker for the Heart of Atlanta Group. This is Broker Chat. We have it twice a month. I'm glad you all are here. If you've been on my Broker Chat calls before, this may be a repetitive session, but the biggest issue that I deal with consistently still is questions around the proper handling of earnest money and what happens if it's not delivered. So we're going to talk a few minutes about that. We're going to talk a little bit about the new paragraph in the conventional FHA and VA loan exhibit. And we're going to talk a little bit about closing attorneys holding earnest money and the ramifications of that, and also the forms that are required. And there's not a whole lot of us here on the call, but feel free to raise your hand and ask a question or interrupt me if you need to. I like to have an interactive conversation, so feel free to pitch in or jump in if you want to. So, earnest money. This is a topic that I continually talk about because, amazingly, a lot of agents still don't understand the process and what happens. I had an agent that got upset with me this morning because the other side had not collected the earnest money, and she felt her client was due compensation. But the fact of the matter is, if it's not collected, it's not collected. And what happens in that case is that you as a buyer's agent or you as a listing agent, this is probably one of the most important things that you need to stay on top of at the beginning of your transaction, is to make sure that earnest money gets delivered. Please don't accept contracts and talk to other agents who may be wanting to make an offer on a listing if you have a listing, but please make sure that your buyers and sellers understand that we don't want to wait 3 days for earnest money to be delivered. Okay. The reason why is I looked at a contract this weekend. They have 7 days of due diligence, and they wanted to submit the earnest money 3 days after binding agreement. And I told them no. And the reason behind that is because if on that third day they haven't submitted the earnest money, then we have to notify them of their breach on official notification form. It's called notice. I can't recall what the GAR form number is, but it's a very underused form, and we need to be using it more in our transactions because we're still a paper-driven industry, and we need to have paper in the file in case there's a dispute. I need to know what to look for, and that all parties were notified if we're having to handle a dispute over earnest money. So back to my conversation, if we hadn't gotten that earnest money on the third day and I had sent notice, then they have 3 banking days to make good on the earnest money. If they don't make good on the earnest money within 3 days, on that 4th day, the seller can terminate the contract or move forward with no earnest money. And I will tell you, in my 25 years of being in real estate, I've never seen a seller move forward with no earnest money if earnest money is part of the contract. Earnest money is not required, but that's the only liquidated damages that you have should a party default on their contract. So make sure that you are collecting that money right when you go binding. That's the best case scenario because, if during that due diligence somebody pokes a hole in the wall, your seller may be entitled to some compensation. So keep that in mind. Stay on top of that. The most important thing you can do as an agent is stay on top of the handling and delivery of the earnest money. If it's not delivered, party's been given notice. They still haven't made good. Make sure you terminate that contract, because that's the beginning of a really bad transaction. So are there any questions about that? Are you all following up on the earnest money delivery? I know you get very, very busy, and I can't tell you how many calls I get from agents saying they didn't deliver the earnest money. Now what? Okay, well, did you notify them? And if you notified them, they have 3 banking days to cure the default. And if not, then the seller has to terminate the contract or move forward with no earnest money. But why would they do that? Mika, how are you this morning?
I'm good. How are you?
Good.
So I remember this conversation. It may have been on the last brokerage.
Speak up, you're a little faint.
Huh. Can you hear me now?
Yeah, I can hear you. It's just very faint.
I don't know what that's about. Let me try something. Okay. Hopefully this is better. So my question is, if it was something around, if the buyer did not turn in the earnest money within the time on the contract, it's a point where they could not cancel the contract for any reason in due diligence because they're already in breach. I'm working to understand exactly what it means. If this, because some buyers will say, well, I didn't turn in the earnest money, so I could just cancel in due diligence. And if I'm not mistaken, Deborah said it's not that simple. So can you verify what she may have been meaning by that? We can't.
Yeah, it's not. It is not that simple. You can't. Right. There is a process, and I just explained that by the end of the business day, you need to notify the party that they are in default of the contract, and you use a notice form in order to do that. Sorry, guys. I just was told I'm going in and out. I don't know why.
I'm sorry.
Okay. It seems fine now.
Okay.
All right, good. So you've got to notify them in writing, and then they have 3 banking days to cure the default. On the 4th day, if they haven't cured the default, the seller has the option of terminating the contract or moving forward with no earnest money. But my take on that is, if they haven't made good on, if they haven't delivered the earnest money, it's a clear sign that it's probably not going to close. So you might as well go ahead and terminate the contract via unilateral termination. But you do have to give that written notice and give the buyer the ability to cure the default. Does that answer your question?
And as the buyer, if they're terminating, let's say something happened, they couldn't turn in that earnest money in the amount of time they were supposed to, and they still have days left in their due diligence, they could still send over a unilateral termination saying that they were in due diligence and still be able to obtain their and not have to pay the earnest money. How does that work?
Yeah, I mean, you could always terminate during your due diligence period, but if I'm a listing agent and that earnest money is due before the end of the due diligence period, I'm going to put you on notice that you're in default of the contract.
Right. Okay. That's what I need to know. Thank you so much.
Tom,
so just because they're in due diligence doesn't mean that they can just automatically not pay the earnest money, because the earnest money is due on a certain date once you go binding.
Tom?
Yes.
I had a question. I was I was the listing agent and the buyer's agent. They weren't late on their earnest money. Well, they didn't end up being late, but the agent said to me, I advise my clients not to pay the earnest money until there's been an inspection. How do I respond to that other than that? That's really wrong.
Yeah, that's not an option unless you have given them X amount of days from binding agreement date to produce that earnest money. They have to produce it. that's not an option. Just because they haven't had their home inspection doesn't alleviate them from delivering the earnest money.
Right, yeah.
That's why I said, from a best practice point of view, you should always collect the earnest money once you go binding. In other words, this buyer that wanted to submit it 3 days later after binding, I said, no, we want within 24 days. I'm sending them written notice they're in default of the contract.
Mhm, mhm.
Does that make sense?
Yes, thank you.
Okay. Now, let's
Hey,
go
Tom.
to, yes.
Hey, I just wanted to chime in on the earnest money. Everybody needs to understand that earnest money is a penalty. If they default, that's what we fall on is earnest money. And back in the day, we collected the earnest money before we wrote the contract. And now everybody's
That's right.
putting 2, 3, 4 days after binding, and that's why you're running into this problem. It's a gimmick. Let me see if I can inspect the property before I give up any money, and then you don't collect and you run into that problem. So you guys have control to stop that problem by collecting it when you write the offer.
Yeah, I did that this weekend. I told buyer's agent, no, we're not giving you 3 days to produce the earnest money. If you can't produce it within 24 hours, we're not taking your contract. So let's move on to part 2 of this. So we have collected the earnest money. It's been deposited. And now let's just say the buyer terminates outside their due diligence period and they don't have any more contingencies. Okay. And they want their earnest money back. And the seller's like, no, I am due the earnest money because you've defaulted on the contract. And we cannot get a unilateral termination signed. So what happens at that point is that we, the holder, and this is why I caution you in allowing closing attorneys to hold earnest money, because we, as the holder, have the right in the contract to disperse the earnest money based on
Hey, I'm here to pick up a rider that y'all printed for me. Perfect. Susan Hawkins.
Do you know what it says?
It just says co-listed with Susan R. Hawkins and then my QR code. Perfect. And then I was supposed to have the 2 little hooks.
Let's
Yeah.
let's
Well, the
find
one
out.
it's hanging on, they've already got the little metal screw eyes.
Uh-huh.
So what is it, like a little S hook or something that y'all
It's a clip.
have? Okay.
Susan, we can hear you. I think
Oh,
you're not.
I'm sorry.
No. Sounds like a really
I'm-
interesting conversation.
I'm picking up my rider. Everything else is quiet, so I didn't realize I was not muted. Thank you.
You're welcome.
Did anyone else have a question while we're trying to get Tom back? I'm driving, so if I can answer a question on here, I can do that, but
I have a question about a 10-day letter.
go right ahead.
Is there a time frame associated with when, let's say, we unilaterally terminate for financing, and this is a Mika situation, but we gave the seller some time to rectify what keeps us from going under contract, which is the FHA approval of condo. Long story short, we've given them some time, and we want to possibly do the 10-day letter. Is there any timeline associated with when we get our denial letter and when the 10-day letter is to be sent if the seller will not sign the unilateral termination?
No. And one of the reasons it's not there is we really, as the contract committee, we always want to try to remedy things. But if you know you're not going to be able to remedy it, we don't want to put a time frame on it. So in Midtown, one of the things I will say is once I get notification or once the attorney gets notification, they're not sitting around just waiting to write 10-day letters. What the contract says is reasonable, and we all know what reasonable means. Reasonable could be tomorrow, reasonable could be next week, reasonable could be next month. I usually wait a little bit because sometimes you guys work it out. But once you do the unilateral and and the 10-day letter is only if there's a dispute as to who is receiving the money. There is no reason to do a 10-day letter unless there's a disagreement as to who should receive the earnest money. So if you're doing a unilateral and you notify the other party the money's being returned to XYZ, and everyone is fine with that, because remember, one part is notification, the second part is saying where the earnest money is going. Does that answer your question?
Yes, ma'am, it does. Thank you.
Good.
Okay,
You're
Deborah,
welcome.
I'm back on my phone now. Can you all see me and hear me okay?
I can hear you. There was a question, Tom, about the 10-day letter and time period, and I said it really, the contract just says reasonable, and so it has to do with really when the broker or the attorney has time to get that letter done, and as long as the broker and the attorney have all the information, contracts, all of that, so they can follow the paper trail and determine, as the contract says, who is going to receive the earnest money. If the broker and the attorney don't have everything, the complete contract, or can go into command and look at your paper trail, then it'll take that much longer to get that letter done, because we don't know that we're responding based on the proper information.
Hey, I'm back now on my phone. Can you guys see me and hear me okay?
Yes.
Okay, super. Sorry about that. I had to go to plan B. Thank goodness for smartphones. So I heard the last part of that discussion, and Deborah is absolutely correct. We actually have a form that we created for the Heart of Atlanta group. If we have to issue a 10-day letter in case of a dispute over the earnest money. And so if there is a 10-day letter requirement, just email me and I'll forward you the information that we need in order to process a 10-day letter. Any other questions regarding earnest money and the dispute resolution? Okay, let's move on to another topic that I want to cover, and that is the closing attorney holding earnest money. And you all know how I feel about that and what I've experienced when closing attorneys hold the earnest money. But the one thing that I see 9 times out of 10, there's never an F511 agreement attached to the F510, closing attorney acting as holder of the earnest money. Both forms are required. And it says at the very top of the form that, you have to use an F511 if you're issuing a closing attorneys holding the earnest money. I've had instances where attorneys, and this just happened last week again, where the attorney said, I didn't agree to hold the earnest money. So what happens is that, the buyer, if they're in default, they're going to get their earnest money back, guys. So make sure that when you accept a contract or issue a contract where the closing attorney is actually holding the earnest money, that you attach both forms, the F510 and the F511. The 511 has to be signed by the attorney's office in order for them to become the holder. Are there any questions around that?
Hey, Tom.
Yeah.
So if you're a listing agent and you got, a contract that said that they were having the attorney hold the earnest money, I mean, I know that's something that you can push back on. I mean, would you, if you receive something like that, would you say, hey, we'd prefer to have our brokerage hold it, or how would you handle that?
I dealt with that this weekend, as a matter of fact, on one of our listings, and they wanted the closing attorney to hold the earnest money. And I said, absolutely not. It's got to be Keller Williams. And so they agreed to it because they wanted the house. Now, that being said, it worked out in this instance, but I would not encourage you to lose a deal over who's holding the earnest money. But I do want you to understand what the ramifications are and the issues that I've dealt with when that attorney is holding earnest money. And quite frankly, most attorneys, they don't want to hold it. They do it as a courtesy, but you're much better off. And I would negotiate that hard if I were you, because I've never had to interplead earnest money ever. And I see too many times the attorney, that's just their standard protocol. They will not take a position. They will not interpret the contract. They will just simply interplead the funds to a court. And what that means is that nobody's going to get a penny, because after they take their reasonable court costs and attorney fees out of that earnest money, there's nothing left. So if that becomes an issue, you're better off trying to settle with the other party to get something. Otherwise, neither party's going to get anything.
So does the attorney have the final say? Like, what if everybody's in agreement, like, okay, we're canceling contract because of whatever, and so earnest money should be returned? Could there still be an issue with the law firm at that point, or no?
Not as long as there's either a unilateral termination signed by both parties or a mutual termination signed by both parties.
Okay. Thank you.
I'm just telling you what I've experienced when they're holding it and there's a dispute.
Okay. Thank you, Tom.
Sure. Okay. The last thing I want to cover with you guys today is there is a new paragraph on the conventional FHA and VA financing forms. And I think it's paragraph 4 or 6. It's on the front page. And it says, when it is known, the buyer will notify the seller of their intent to proceed with their loan. Now, this is something that's come up. I've dealt with, and it particularly brought me the awareness to me when I took a class from an attorney. And this attorney's position was that if we, as a buyer's agent, do not notify the seller of our intent to proceed, we are in breach of contract, and at that point could lose our earnest money, even if we're still within our financing contingency. So there is and all lenders have a form that the buyer must sign of their notice of intent to proceed with their loan. That really starts the whole loan process in terms of ordering the appraisal and getting documents together so that the loan officer can process the application and get the loan underway for closing. So best practice, again, that notice form that I mentioned earlier in the call is a great form to use to notify the listing agent that your buyer has signed the letter of intent to proceed with their lender. And it would be especially good if you get a copy of that notice of intent to proceed from the lender and attach it to that notice form. And that way you will have fulfilled that obligation. So recently we had a dispute over earnest money, and I have gone over this a couple of times on these calls, and I was just waiting for the first issue to arise, and it did arise, where the listing agent, the buyer terminated, and the listing agent said, well, you never sent us your notice of intent to proceed, so our seller wants the earnest money. And even though they were within their financing contingency, they did not fulfill that part of the loan of the loan, and therefore they lost their earnest money. So please make sure, if you are representing your buyer or a buyer, that you pay attention to that and send that notice of intent to proceed, attach it to a GAR form notice form, and send it to that listing agent, and make that part of your command file in case we need it for review. So I'm sure you all have some questions about that. So I'm going to open up the floor here for a few minutes and let you ask your questions.
Tom, isn't it for conventional too? I thought I just heard VA and FHA.
No. Conventional, FHA, and VA, all three.
Okay, that's what I thought. Thanks.
Yeah. Anybody else?
If for some reason, let's say we sign the intent, or they get this letter of intent, we send it over to the seller, and then for some reason the underwriter comes in at the last minute and says, oh, you need this, that, or we're not going to do this, and the buyer chooses, then we're going to pay cash. Is that an option? Do we have to, is that, or would that just mean, no, the contract's done?
Well, if that were the case, if that were the scenario, I would advise you to send an amendment over to the seller's agent, asking, and telling them that we are now going all cash. Because that seller's agent, the listing agent, if they're a savvy listing agent, they're gonna want to see proof of funds. So it's all good and fine to say, well, we're gonna go cash, but that starts a whole nother conversation. If I'm a listing agent, I'm going to want to know that you have the cash close. So an amendment in this case would be required. But if you do not do an amendment and you still need, well, you're going to have to amend it, because otherwise that paragraph in the financing exhibit is going to prevail. If you don't amend that contract, you still are going to have to provide notice of intent to proceed. And if you don't, if you're going to go cash, you're not going to have notice of intent to proceed, because you're not applying for a loan. So you're going to have to amend the contract at that point.
Okay.
Does that make sense?
Yeah, it makes perfect sense.
Okay, good. Any other questions around those two things? So really what I wanted to hit on today, and I got to wrap this up to get to my appointment, is that, the importance of making sure the earnest money is delivered and deposited per the contract. You know what the consequences are. If it's not, you better stay on top of it. And the 10-day letter process, if there's a dispute over the earnest money, once it's been deposited, and the notice of intent to proceed, if your buyer is getting a loan, in order to send that form. And honestly, you should be on top of that anyway, because that's what starts the whole, a lender's not going to even order an appraisal without that. And we're on deadlines in our contract. So it's an important thing for you to stay on top of. Those two topics get more transactions in trouble than anything else. Any questions, guys? Anything else that I can assist you with today on this call? Y'all are being awfully quiet. Must be Monday. All right, then. If you have any questions, I'm only a phone call, text, or email away. So I hope you all enjoy your day. I hope this has been productive for you. And we will see you in a couple of weeks on our next broker chat call.
Thanks, Tom.
Thanks a bunch.